On PlainSpoken, a lot of the stuff that I cover deals with law, legal stuff, and that is not my area of expertise. I have a brain that has a very hard time holding on to these details and procedures and the terminology. I need help. And from the very beginning, I've been aware that there are some key players that are kind of in the middle of this. So Dan Dalton of Dalton and Tomich has inserted himself in the middle of all this and has defended a lot of churches, represented a lot of churches in their efforts to get out. The National Center for Life and Liberty, with Gibbs and Bailey and others, have also had their own approach in annual conferences, doing these larger kind of class action things. But they are not the only lawyers in the mix. And I recently discovered Lloyd Lunsford, who I'm going to be interviewing today, and he has his own expertise. And I'm going to give him a formal intro here in a second, but just something to keep in mind as we get into this conversation with law is, one, I'm not very smart, and so you're going to have to read between the lines of my stupid questions to kind of get the wisdom from Lloyd that you and your church need. But secondly, law, it seems to me, we have this notion that it's an objective, dispassionate standard that can be interpreted the same way by reasonable minds. And what I have found as I've talked to different lawyers and professionals in law is that it's really very difficult to come to a shared notion about much of anything. And that's, of course, what a court case is about, is matching the words that we have ensconced in American law and applying that to the real world and seeing what principles and forms of reasoning prevail. So it's very intimidating for good reason, but that doesn't mean that we shouldn't even try and understand it and throw up our hands and go, it's lost. Rather, we have to do the best with the authority and trust given us to make good decisions with that which has been entrusted to us, namely the local church. Because if we just sit and do nothing, well, I think that's often to the benefit of Satan. So if you are in a church that is wanting to explore options for disaffiliation, your conference has closed the door, and you have prayerfully worked through 1 Corinthians chapter 6 and the warnings of litigation, and you're just wanting to look at the different options, what's going on, I think this will be a really good conversation for you. So I would urge you to just tune in and just be in a very gracious spirit with a not very smart host and a difficult topic, and we'll see if the Lord brings about some good in some people's lives through this. So let me give a proper intro here. My guest today is Lloyd Lunsford Esq. He is an attorney with a large Baton Rouge, Louisiana-based firm who has practiced law for almost 40 years. Among his specialties is church property law. He served as the general editor of a guide to church property law. It's a 475-page treatise published in 2010. He's been advised and represented scores of local churches from coast to coast in several mainline denominations as they've navigated denominational exits and their denominations-related property trust claims. He's represented Episcopal, Presbyterian, and Methodist churches in 35 different states, ranging from 20 members to 25,000 members, with the value of local church assets ranging from just a few $100,000 to over $100 million. So he's been all over the place. Since 2019, he's kept busy primarily representing Methodist churches that have gone through the paragraph 2553 disaffiliation process, which we're all familiar with by now, hopefully. As a boy, Lloyd attended a Methodist Sunday school where the early seeds of faith were planted in him, so he knows a little bit about us Methodists. As a teenager, those seeds bore fruit as he came to personal faith in Christ Jesus through the ministry of Billy Graham. So as a young man, Lloyd was married in a United Methodist church, and before attending law school, Lloyd worked on Capitol Hill and then served on the staff of Campus Crusade for Christ. I think nowadays it's called Cru. After a lengthy full-time legal career, he's now semi-retired. He tells me that his favorite court has become the tennis court. He's to be near their grandchildren. He and his wife Cynthia now make their home on the shore of a lake in the Blue Ridge Mountains of western North Carolina. So he's in a privileged place to speak to us today, both materially and in knowledge. Lloyd, thank you so much for joining me today. How are you doing, brother? Is it a good day?
Thank you very much, Jeff. It's a pleasure being with you. It's an excellent day.
Very good. Yes, we were able to connect finally after Zoom is a very simple platform, but kind of gets complicated sometimes. But it's an amazing thing that you can be in the Blue Ridge Mountains in North Carolina and I can be in northeastern Oklahoma, and we can connect and have a conversation like this. So just feeling very blessed this morning. So thank you for taking the time. You and I have been talking privately. You've been helping me speak in a little bit more informed manner about the legal affairs in Oklahoma as we're approaching. We've already had a court case with Oklahoma First Church. Church of the Servant is another large church in Oklahoma City that's filed against the conference. A lot of different opinions on what's going on. You've helped me understand ecclesiastical abstention doctrine. And then I've had some other lawyer friends that have kind of added some nuance and talked about neutral principles law. We'll get into that in a little bit. But I gave a brief intro about you and your experience in this part of law. You referenced a tome that you edited or contributed to. Do you have that handy? Okay, that's the book right there, A Guide to Church Property Law, second edition. Oh, and look at your name right on the front there. So did you author the whole thing?
Well, the original concept was it would be an anthology with several contributors whose names would appear next to their contributing chapters.
Mm-hmm.
And I ended up writing about 2/3 of it. And
Okay.
so the publishers thought it would be awkward for my name to appear so frequently. So they said, why don't we make you general editor and put your name up front on the cover?
Yeah.
And I was happy to oblige. I did it as a service, waived any royalty interest. So I have no pecuniary motive to selling books. It's, I think, a very useful analysis, mostly in conversational English, about this unusual niche area of the law.
Mm-hmm.
For which there's been a spate of cases about every 30 years, going back for 200 years in American history. There's nothing new under the sun.
Right.
And I think it's available on Amazon.com for those interested.
So it is still being sold. And do you think it would be useful for local churches that are looking at litigation to consider? I mean, would it be helpful in that situation, or is it more for law nerds?
Well, no, it's written with a general lay audience in mind. In fact, there's a specific chapter devoted to Methodists, although it was published before 2553 was ever conceived, much less added to the Book of Discipline. But it has some thoughts from Thomas Oden and others.
Oh, interesting.
But it deals with more fundamental issues of common interest to whether you're Presbyterian, Episcopal, Methodist, AME, or other religious traditions in this area of church property rights.
Okay. Well, I'm going to make sure to have a link to your book on Amazon for anyone who wants to think about purchasing it, because it's always good to do your homework and your research. So a part of understanding what a local church should do right now is just understanding the landscape right now in the U.S. And of course, the picture is too big for us to cover very briefly, but there, I think, are 5 or 6 larger NCLL lawsuits going on in different annual conferences, like Florida, North Carolina, and Baltimore, Washington, I think, are the ones that I know about, but I know that there are others. There's also Dan Dalton, who's served churches like Asbury United or former Methodist in Tulsa, or Jonesboro Methodist, or Searcy in Arkansas, which of course Jonesboro didn't go very well. But in North Georgia, there's been some dust-ups as the conference tried to suspend the disaffiliation process, and the courts got involved and said, no, you have to do what has been decided will be done. There's been a defeat in North Carolina as the judge dismissed the lawsuit, I believe, and I forget on which grounds. There have also been, I covered one case in Louisiana that I'm thinking you're connected to. What other, do you have ongoing cases right now that are in the United Methodist Church? Are there any churches that people should or would know about that you're representing in court?
Well, there's major litigation in the West Florida, South Alabama conference involving Harvest Church in Dothan,
okay,
where my firm is representing the local church. And while I'm not involved as counsel of record in the SMU litigation, in the Texas Fifth Circuit Court of Appeals just issued a major opinion in that case earlier this week. You mentioned most of the major cases involving Methodist entities that have been filed or pending. And it may seem like there's litigation all over the place when you list them all together like that. But looking at it from a 30,000-foot level, Methodist litigation has generally been the exception rather than the rule. Most of the reported cases on the law books have been Episcopalian or Presbyterian. The Methodist cases are comparatively few in number, primarily for two reasons, I think. One, the Methodists were able to sort of kick the can down the road more effectively on these matters of human sexuality because they would only meet legislatively in general conference once every 4 years.
Right.
Whereas their Presbyterian and Episcopal brothers and sisters would meet either annually or every other year. And so it came to a boiling point a little bit quicker in the life of those denominations. Secondly, I think the reason that Methodist cases land in court with relative infrequency is because the UMC did something that the Episcopal Church and the main body of Presbyterians, the Presbyterian Church USA, did not do. The UMC amended its constitution to provide for an alternative to litigation, hopefully, an administrative path to the exit door, which was 2553, paragraph added in 2019. There was no similar provision in the Episcopal canons, and the only similar provision that existed in the Presbyterian Constitution, the Book of Order, as it's called, was effective between 1983 and 1986 and expired or sunsetted then.
Really?
So contemporaneously, there was no alternative other than the courthouse door. Whereas Methodists have had an alternative, which in most cases, in most conferences, has been able to be applied with an outcomes that were mutually acceptable to both sides without going to civil court. Some conferences have, as you know, have been imposing some very high financial demands above and beyond a year or so of apportionments, above and beyond a fee related to unfunded pension liability, if there is such liability, but something, a percentage of value of the local church's assets. Most conferences did not impose that. Some have imposed a fee of as high as 30% or 50%, I think the California conference has imposed, which is the deal killer.
CalPAC and Baltimore, Washington have both put a 50% property value on. And I'm remembering now Eastern Pennsylvania Annual Conference also has an NCLL lawsuit going on with what I want to say 50 churches because they have been given very burdensome fiscal.
Right. And there's some very fine lawyers with that organization. I'm not going to throw stones at them, but the class action suits that they have filed are going to face some significant procedural hurdles in some jurisdictions. This whole issue of church property law is a state law question, and states can address it in different ways. A handful of states, Florida, New Jersey, Michigan, as a practical matter, Georgia and California, resolve these church property matters when a civil court addresses them by simply determining what the denomination has said and then deferring to that.
Right.
Most states, however, apply ordinary property and trust and corporation law that would apply to anybody, irrespective of the religious identity of the parties.
Would that be the neutral principles?
That's the
standard?
neutral principles of law method. And those cases, outcomes are based on the facts of a particular case.
Okay.
You look at the deeds of the local church and its articles of incorporation and so forth.
Hmm.
And so, in states that apply neutral principles of law, by definition, you can't have a one size fits all outcome,
Hmm.
and which is what you're looking for in a class action suit.
In
So
class
a suit,
action suit, you're not looking for neutral principles. You are looking for a new standard of judicial decisions, changing the
well,
status quo.
I'd phrase it a little differently. A
Okay.
class action suit is looking for a judicial decision that would apply equally to everybody,
Okay. Rather than getting
everybody
in the
in
nitty gritty for
everybody in the
each church.
class.
Okay. I understand.
But in a state like say Texas, for example,
Hmm.
where neutral principles of law apply, there is no one size collective answer. It's a church by church by church analysis
Okay.
based on the facts of the particular case. Now, in Florida, where I think the NCLLS, I'm getting the
NCLL.
initials
Yeah. National Center for
garbled,
Life and Liberty. Yes.
have found Florida is one of those deference states
Right.
where the challenge isn't that a class action suit doesn't really fit with neutral principles. That's a case by case by case determination.
Hmm.
But this roadblock that you're going to find where the state court is just going to defer to the denomination.
Hmm.
And lower courts are bound to follow the Florida Supreme Court.
Hmm.
So you're going to lose in the lower courts and hope that the Florida Supreme Court grants review of the case and changes the law. But most states are going to apply ordinary trust law,
Hmm.
which requires something other than what's in the Book of Discipline in order for there to be an actual enforceable legal trust.
Hmm.
The owner of the property, the local church,
Hmm.
has to put something in writing. And in Methodist circles, local Methodist churches often have
Right.
in their deeds and in their articles of incorporation. And so then the question becomes, in that state, can that language be lawfully changed?
Right.
Which was an issue in Texas in the Masterson case. I think you've talked about that before,
For
and
our
more
listeners,
recently in the SMU case.
for the listeners, let me put it in my own words to make sure
Yeah.
it's hitting. Whenever this stuff enters litigation, the state sometimes can and will make a ruling on whether or not the property can or should be handed off to the local congregation based on what is in writing in legal documents. So if there's a trust or any kind of property documents that have anything in writing that gives the property under the ownership of the denomination and designates the locals as trustees, that's really bad. But if there's anything in writing that doesn't have that, or that even stipulates that the building and assets belong to the local congregation, then you might have better legal grounds to stand on. How'd I do?
I think that's a fair way to put it.
Okay.
It's important, I think, for local church pastors and lay leaders in churches to understand that there's a difference between being the owner of the property
Hmm.
and whether or not there's a trust over that property in favor of a non-owner.
Hmm.
It's almost always the case that the legal owner, the legal title, is in the name of the local church. But sometimes in that title or in that deed, the owner has delegated to somebody else a right to determine who gets to use and occupy the property. That's what a trust is.
Okay.
And so, for example, if you own an apartment complex building and you sign a lease as the landlord, that's giving somebody else a right to occupy that property for the term of the lease.
Hmm.
But you're still the owner of the property. But it's just someone else has a right to occupy it.
Right.
Well, in a trust, the owner sometimes creates a right to occupy or determine who gets to use the property to somebody else. And often the case in local Methodist deeds and articles, that right has been given to the denomination.
That's interesting. So usually the way people talk about it is the denomination is the owner, and they allow the local church to be trustees of the owner of the property. But you're saying it's actually the opposite, where the local church is the
Yes,
owners, but they have deferred authority about who can use the property to the denomination.
that's correct. And these issues that I'm talking about, and it'll be helpful to understand, is they rarely arise in Baptist churches or Catholic churches.
Okay.
They will arise in if you think of a spectrum of forms of church government. In the middle, you've got Presbyterians, Episcopalians, Methodists,
Yeah.
Lutherans, and so forth. And at the opposite ends, you've got Congregationalists, Baptists, and a very strictly hierarchical organization, the Catholic Church.
Yeah. Yeah.
These issues of the tug of war between control don't come up in the Catholic Church because the legal owner in the Catholic world is usually not the local church. It's
Right.
not the local parish. It's the diocese to begin with.
Right.
So this trust right doesn't even come up.
Mm-hmm.
On the other end of the spectrum, in Baptist circles, they are very congregationalist. So there is no district or regional or national body to kind of have a yin and yang with.
Yeah. That's what
But in these
congregationalists.
intermediate forms where power is shared,
Yeah.
that's where these issues arise.
Yeah, for lay people watching this, a congregationalist system is a non-hierarchical system. There's usually not any kind of bishop or diocese or annual conference. There's voluntary associations that they associate with, but they don't ever exercise anything like the authority or control that you're finding in these middle of the road or very hierarchical.
Intermediate forms of government.
Yeah.
For example, even the most well-known Baptist organization, the Southern Baptist Convention, is not really a denomination in the normal sense of the word. Even their local churches have 100% autonomy to begin with.
Yes. Let's retrace our steps a little bit, because some texture to the history of real estate and disaffiliation in the United States. I recently interviewed someone who came out of the ELCA, and that was, of course, the Lutheran mainline denomination, and they went through this split a while back, and they were able to do it without much litigation because the ELCA did provide a sort of way out that I would consider akin to, there used to be a paragraph that was active in the United Methodist Book of Discipline, 2548.2, which allowed a local church to transfer to another evangelical denomination. And it was a very broad language that, to my knowledge, was used dozens, hundreds of times in various annual conferences behind closed doors with NDAs, where they would negotiate the terms on which a local church could disaffiliate, do any kind of payout, leave the denomination quietly, and join another denomination. But then our judicial council, whenever we invented 2553, ratified 2553, just said 2548 is now no good. 2553 is the sole disaffiliation passage now, which I've always thought was an odd decision. Did you do any cases before 2553 in the UMC under paragraph 2548? Was that anything that you ever touched?
Candidly, no. I'm familiar with that provision, and its language is interesting. Whether or not it will be reactivated when 2553 sunsets, and no successor provision to 2553 is added at the next general conference, remains to be seen.
Yeah.
Assuming that it is reactivated, it's phrased in an interesting way. It says that as part of that 2548 process, the conference will transfer title to the new denomination that the local church is joining. But in almost all cases, the conference isn't the title owner to begin with. The local church is. At most, all the conference has is what's called the beneficial interest, which is a synonym for a trust interest.
Well, let me stop you real quick, because when my churches went through the disaffiliation process, we took our vote in April and then finalized all the paperwork, and then we were submitted legal documentation from the annual conference. I want to say it was a quitclaim deed.
A quitclaim deed, yes.
So you don't have to be the owner of a property to issue a quitclaim deed?
Well, what you have to understand what a quitclaim deed
Yeah,
is.
I don't.
Yeah,
Help me.
and quitclaim deeds, to give an example where they're often used in your neck of the woods, in the oil patch of Oklahoma and Texas, is oil company wants to come in and drill a well.
Mhm.
And there is a big pool of oil under the ground that is underneath land owned by a lot of people.
Right.
And so the landman from the oil company goes knocking on farmhouse door to farmhouse door, saying that we want you to transfer your whatever mineral interest you may have
Mm-hmm.
to us, in exchange for which we will have a shared unitized well, and we'll farm out royalties
Okay.
to the different surface landowners. And the farmer doesn't know what mineral interest he does or doesn't have.
Mm-hmm.
And so what the oil company does is they give him a quitclaim deed to sign. And the farmer says, well, whatever rights I may have, I quit and I convey to you. So in the Methodist property world, what happens is, as part of a 2553 dismissal, both sides executed a disaffiliation agreement. Some conferences require the local church to form a new corporation and transfer its assets to new corporation. The local church pays the conference X dollars, and in consideration of that, in exchange for that, the denomination through the conference quits any property rights it may have. Now, whether there's a valid trust or not is often in dispute.
Mm-hmm.
So the parties don't want to say there is a trust or there isn't a trust, because that potentially is in dispute.
Mm-hmm.
So a quitclaim deed is used as a convenient device to wrap a bow around it and tie up that string. And the conference says, in effect, whatever rights we may have, we relinquish and convey to the local church.
So it's not necessarily we own this and we're giving it. It's more we might own this and we're not going to try and claim it ever.
Well, they're not even saying we might own it. We're saying we might have a trust right over it.
Okay.
Usually it's not disputed that the name on the title, and the only name on the title as legal owner, is the local church.
Mm-hmm.
But where the dispute is whether or not that local owner has conveyed a trust interest that's legally enforceable or not. The denomination says it has,
Mm-hmm.
and therefore they can control who gets to use it. It's sort of a sword of Damocles that's hanging over the head of that local church. And as part of this financial settlement, they're saying we're going to remove that sword of Damocles, or that potential sword. We're going to give up whatever.
That's such a good reference, but most people aren't going to know it. In ancient Greece, there was a sword of Damocles that hung over the throne of the king, whoever was there, with the knowledge that it could drop at any time. So it creates a state of just perpetual paranoia and anxiety about this impending harm. Right. And so whenever before a conference gives the quitclaim deed, then hypothetically they are this sword that could fall on a local church at any point in time as they show up as the ones in charge of this trust who can then dispossess a congregation of its property.
Right. If the claimed trust right is legally enforceable and valid, the denomination could evict non-cooperative
owners. See, that's the thing that really it drives people
and
like me nuts.
Seize functional control of the property.
Right. So people like me who look at it go, if you tell me that on our legal documentation it says we are owners, then that's the end of the case for me. But what other legal experts say is, no, actually, if there's a trust in place and the annual conference has been put in trust of this property, they can dispossess the owners, in which case that just makes no cognitive sense to me, but that's what everybody
you're,
says.
You're absolutely right. Oftentimes, denominations will utter reassuring things to pastors and local congregations saying, "You're the owner of the property. We have no interest in becoming the owner." And everybody breathes a sigh of relief. But what's unsaid is, but we claim a trust right, where we get to determine who really gets to use the property, whether you're the owner or not.
And that's
Now,
the same in all 50 states. That's the legal case that they make whenever they try and file under 2549 to declare exigent circumstances and take the assets. This is the uniform case they make. We have been put in trust of this property. We need to dispossess the owners of what they've accrued here.
And they say that across the board, coast to coast, based on what they have put in their denominational constitution.
Okay.
But for example, you have a house in a subdivision, and you've got a homeowners association that has articles and rules and so on and so forth. But it's only your name on the deed. You're the one that's paying the mortgage,
right?
Cutting the grass, paying the insurance. If I were to drive through your neighborhood and take a liking to your home, and was able to persuade your homeowners association to change its rules to say that I have a trust over your property and can determine who gets to live there and occupy it and use it, your reaction would be, what?
Right. Yeah, that's crazy.
What gives them the right?
Yeah.
Well, under ordinary neutral principles of law, standard trust law applicable in most states, only the owner has the right to create a trust on behalf of somebody else. So what's in the denominational constitution is something that the would-be beneficiary has put in writing. But if that's to be effective, you as the owner have to put something in writing, either in your deeds or in your articles of incorporation. And in the Methodist and in the Episcopal and Presbyterian world, you rarely find that. Sometimes you will, but it's the exception rather than the rule. In the Methodist world, though, there is this long tradition of a trust.
Yeah, trust clause.
And so you will often see trust language in local deeds and articles. In the Episcopal and Presbyterian world, this trust issue, at least in expressed written trust, didn't really surface until the late 1970s, early 1980s. But in the Methodist world, it dates back to the 1760s.
Right, yeah, yeah. But even in the Presbyterian and Episcopalian worlds, even though they didn't have that language in their deeds very often, there was still massive litigation, and in a lot of places, denominational authorities came out on top, right?
Well, denominational authorities in the Episcopal and the Presbyterian world came out on top in deference states where ordinary rules of law aren't applied, and the courts, as a matter of policy, just adopt what the denomination has said. Or there were cases in neutral principles of law states where the court found a trust through language that was indirect or inferential in some articles or some deeds. Sometimes courts will find a trust for reasons of fairness and equity to avoid unjust enrichment, called an implied or constructive trust, where the denomination donated all the land and funded the building to begin with.
Okay.
And so in fairness, they find a trust exists. But there were many cases in particularly the Presbyterian world where courts ruled in favor of the local congregation, that there was no actual enforceable trust, because there was nothing under ordinary trust law that the owner declared a clear intent to create a trust.
Let me sum up what I think I've understood us to be operating around, that this is not an area necessarily of federal law, First Amendment protection of division of church and state, but different states have different norms established in jurisprudence, the standards for ruling on cases. Some states just say whatever the church largest church body says that's what's going to happen. We're not going to get involved. We're not wading into these waters. But a lot of other states say, no, we can wade into these waters with neutral principles, at least in the case of property. So we're not going to make any, what happened in the Oklahoma City First UMC case. I was there in court for that. They argued, we're not asking the court to rule on any doctrine on the LGBTQ, sexual ethics, behavior, sexual immorality, none of that. We're just looking at, here's what the denomination put in writing so far as the process of how they're going to lead through 2553. They didn't do it. They invented new stuff that they didn't make any other churches do. They didn't abide by the timelines and the stipulations of these things that they put in writing. They have acted in bad faith. By neutral principles of the law, we need intervention. So what you and I have talked about privately before is ecclesiastical abstention doctrine. You have said that it's only in the case of fraud that a state court can get involved and overturn the decisions of an ecclesiastical authority. The lawyers here are making the case that they don't need to substantiate fraud. They just need to have neutral principles of the law applied in this particular case, which, as you've said, is not a class action. It's not a uniform policy on all churches. It's just intervention in this one church right here. So is the case that they're making here, you've reviewed some of the documentation, but not all, as for obvious reasons. You have your own cases you're doing. But it seems to me, well, and to Judge Timmons, who ruled on it, she didn't use the word fraud. She didn't make any direct allegations. She did infer bad faith. Does it seem to you that the decision can be made and upheld based on neutral principles, or do you think that that standard of fraud really does need to be
let me talk a little bit about the Oklahoma
please do.
litigation.
Please.
With a caveat that I've not, if the court has issued a written opinion, I've not read it.
Okay.
I've not reviewed the record. I've not read the briefs. I'm just familiar with general press reports.
Okay.
Before commenting on that case particularly, let me draw a distinction between the ecclesiastical abstention doctrine, where courts abstain from getting involved,
okay,
versus the different methods they use when they do get involved.
Yeah.
So courts clearly have authorities long established to decide matters of church property. They don't have to abstain just because the parties are religious in some fashion.
So let me stop right there, because one of the things, we're having the special called conference on Saturday. The judge mandated that we have to do our best to recreate the conditions of the April vote for First Church to get the same benefits, because, you know, all the disaffiliated churches left and their votes are gone with them. So it's now going to be hostile if they come before the conference in October. So they've invited delegates from 55 churches that have disaffiliated to come back and vote this Saturday. And what the conference has said is, this is an internal church matter. They cannot interfere with how we conduct ourselves with respect to real estate or any of that. That totally interrupts our church law. This disrupts the First Amendment. And what I just heard you say is, no, there's a long history of the federal and state government getting involved in property disputes in local church matters and denominational bodies. This is not anything new. Have I understood you correctly?
I'm sorry. I was momentarily distracted by grandkid carpool instructions.
It's just fine. So, but I think it's good for me to recapitulate I think you got the general flow of what I was saying. The conference is saying this is an unprecedented overreach on the part of state government. It has no right to get involved in. They say it's not a property dispute. This is a theological.
That's a valid. I'm not saying necessarily a valid argument, but it's a valid and important and significant issue to be answered and addressed.
Okay.
Courts, civil courts, state government has the authority to decide church property matters when they can do so without having to rely on religious doctrine in general. There are some things that state courts cannot exercise their jurisdiction to decide and referee, that they have to abstain from.
Right.
Um, and the U.S. Supreme Court has a body of law that collectively has been called the Ecclesiastical Abstention Doctrine that draws that boundary line.
Okay.
So, for example, a civil court has no business deciding whether or not Pastor Jones is preaching sound doctrine,
Right.
or whether Sister Mary should be baptized, and so forth.
And we're all agreed on that.
Right.
We
and
all,
so
yes.
whatever separation of church and state does or doesn't mean, everybody's agreed about that.
Yes.
Now, the ecclesiastical abstention doctrine says that civil courts cannot get involved in matters of faith and practice and, quote, internal ecclesiastical administration. So the conference, so no matter how arbitrary or capricious or uneven or unfair or inconsistent the denomination may be in applying its own rules, a civil court can't jump in to referee that. That's a matter of internal ecclesiastical administration. And the conference in Oklahoma is saying, well, that's precisely what's going on.
Well, but I think the lawsuit that First Church brought said that they wanted the court to get involved on those premises under neutral principles.
Yeah, and now a court can get involved if the lawsuit that was filed was simply to have the court declare who has what property rights. Now, I don't know who initially filed suit and how the petition reads and what the court was asked to decide in the prayer for relief, but your garden variety, typical church property lawsuit, when filed by a local church, simply is asking the judge to decide whether or not the denomination's claimed trust is or is not valid under state law.
See, and I don't think Judge Timmons spoke to that in her decision.
That's your ordinary church property case in which a court would have jurisdiction. Now, if the lawsuit was filed to say, Judge, they are applying 2553 in an improper way.
They did that.
They're doing X, Y, and Z wrong.
Yes.
The conference will say, well, that's a matter of internal ecclesiastical administration,
which
Judge.
They did.
You've got no
yes.
business weighing in on that.
Yes.
But there's an exception to the ecclesiastical abstention doctrine that does allow courts to weigh in. And that is if the application of the internal rules by the conference or the denomination is more than unfair, more than inconsistent or arbitrary, but is in the implementation or pursuit of fraud, then a court can weigh in. And so the conference is saying there's no fraud here. This is just, they just don't like how we're doing things in applying our 2553 process. And too bad. You know, you can't redress that, Your Honor.
Yeah.
Whereas the conference of the local church is going to say one of two things. They're going to say, well, you do have jurisdiction because fraud is being committed. Or they're going to say, well, this isn't a matter of internal ecclesiastical administration at all. This is just a property matter.
That's the one they did. Yeah, they didn't allege fraud.
And all we're asking you to decide is whether this trust claim is or isn't valid.
Okay, wait, maybe I just understood. Okay, no, there is no circumstance in which a court can rule on theological matters. They can only rule on property dispute matters. But even then, sometimes they just defer to an ecclesiastical authority. But in some states, a church can say, well, but they can allege fraud, but that's not what they did here. They just said we're having a property dispute, so get involved.
Now, so in Oklahoma, let's talk about Oklahoma law for a second. Courts have jurisdiction to decide a church property matter And a state court can do that in one of two ways. They can apply ordinary trust and corporation and property law, or they can defer to the denomination as a matter of state law policy. And I haven't done an analysis of Oklahoma case law in a few years. But my understanding has been that in 1973, the Oklahoma Supreme Court decided the Cimarron case, which adopted the deference method. So even if this is not a matter of internal ecclesiastical administration and is just a garden variety property matter, the local church is facing a daunting challenge because the way Oklahoma courts resolve property matters is to defer to the denomination.
Yeah,
now,
let me
perhaps
add.
that law has changed.
No,
or perhaps they're seeking to change that law, but that's my understanding of the legal landscape in Oklahoma.
My Oklahoma
I could be
lawyer
wrong
friend,
about that though.
She typed out the 1970 in 1979, the Oklahoma Supreme Court declared the deference approach and explained that even under a strict deference approach, the court may make an inquiry into what should be entitled deference. Even the deference approach is not a total bar to a civil court's jurisdiction, but is only a restriction on a court's adjudication of the matter before it. No matter what approach is used, a civil court may exercise equitable jurisdiction in a church controversy for the protection of a civil or property right. The Oklahoma Supreme...
let me stop you right there. What the court was saying is, I have jurisdiction to decide a property matter because the deference method doesn't divest me of authority to decide the matter. I have jurisdiction.
Because
if the property matter,
if they don't do that, then hypothetically a church might just go around saying, we claim this property and there's nothing the state can do about it. There still has to be a check on churches behaving crazy or illegally in a civil sense.
Well, yes.
Okay.
I mean, it's. I mean, so
I shouldn't have caught. Keep going on the road you were going on. Sorry, brother.
So the what the court is saying is, I have jurisdiction to decide this matter. The question is, how do I go about doing that? Ordinarily, the deference method applies, which means I've got to determine what the conference has said and adopt its decision as mine and defer to it. But if they are doing something that unjustly enriches them, that is inequitable, I have some latitude. I have some leeway even under the deference method. That's apparently what the trial court has said. Well, let me back up for just a moment.
Go ahead.
In the early part of American history, during the colonial period, before the First Amendment was ever adopted, colonial courts would often apply what's called the Old English rule. Back in England and Scotland, when there was warring factions over church property, what would happen is the court would decide who gets the property based on the court's determination of who is being most faithful to founding or original doctrines. Well, fast forward to this new republic in America and the First Amendment. Should state courts have authority to decide what sound doctrine is?
Absolutely not.
Absolutely not. The First Amendment acts as a bar to that. So the Old English rule went by the wayside. And in its place, two different methods evolved. And they were called different things, but nowadays they'd be called the deference method or the neutral principles of law method.
Okay.
It wasn't until, and so you see courts applying both in the 1820s and 1830s and 1850s and so forth. It wasn't until the 1880s, 1890s that the U.S. Supreme Court had occasion to weigh in on the deference method that some states were using. And the U.S. Supreme Court said that the deference method, where a state court determines whatever the diocese or the conference or the presbytery has decided and adopts that rule as the court's, that doesn't defend the First Amendment. If a state court wants to do it that way, they're entitled to do it that way. And the federal Constitution doesn't act as a bar. So several states did it that way. But there's a growing awareness that was kind of unfair because local churches would always lose
Mm-hmm.
because a conference is never going to rule against itself.
Right.
And so many states started using the ordinary rules of law that apply to everybody else.
Which seems to be what's happened in Oklahoma.
That became known as neutral principles of law.
Okay.
So in Oklahoma,
yeah,
the deference method, I believe, applies under the Cimarron case. But what the trial judge apparently has said in this First Church Oklahoma City case is it's not quite black and white. There's some gray. I have some latitude if I think something inequitable is occurring.
Mm-hmm.
And she didn't quite use the word fraud, but she apparently, in her findings of fact, found a lot of things that were unfair.
Yes.
And so the conference is saying, well, you've overstepped your powers. There's no fraud here. The ecclesiastical abstention doctrine acts as a solid bar.
Mm-hmm.
The local church is saying it's either a garden variety property matter and you've got some latitude, or if the ecclesiastical abstention doctrine does apply, there's an exception to it because they're committing fraud. So that's the position I think the parties are going to be developing on appeal.
Hypothetically, is it possible that the lawyers for First Church are not making the case for fraud, but the judge herself has determined that fraud is an issue here?
Well, fraud can take many forms.
Yeah.
And it's a malleable concept. It requires purposeful intent. You either actively misrepresent something or conceal something material.
But the question was, can a judge make a ruling in favor of the prosecution, in this case, First Church, even if the prosecution doesn't make that argument?
The court can, on its own motion, its own volition. Lawyers call it sua sponte. They use the Latin so they can charge more. But the court can, on its own motion, find that.
Okay.
But ordinarily, it requires a party to either plead it in writing or to make argument and put on affirmative evidence. Certainly on appeal, an appellate court cannot base its decision on a grounds that a party hadn't asserted.
Would the judge...
So the appellate court is going to be limited based on the assignments of error that the party appealing the decision would have to list in their brief.
Well, but so the judge in the original case would be considered a party?
No.
Okay. So that complicates things because hypothetically the judge provided arguments that neither the defense nor the prosecution utilized in the proceedings.
Yeah, sometimes the judge sort of sees gaps that the parties themselves and their legal counsel, their legal representatives have for whatever reason left unexplored, maybe because they think something else is a stronger argument.
Yeah.
But during the course of the evidence, some things percolate and surface or aggregate to the point where a court is persuaded that this C is really the key issue, not A or B.
Yeah.
And has authority to raise that on their own volition.
See, this is it's like learning to speak a foreign language. There's just all these rules that don't apply in normal life, but they are the bread and butter of how one navigates this world. Let's talk about some cases that are closer to home just to see, because it still has to do with Oklahoma. When I say closer to home, I mean for you, because you were tied to the First Church Shreveport case. You were their representative. You're at Harvest Church Dothan, which is tied to the Alabama West Florida Annual Conference.
Correct.
One of the things that my former conference here is now doing is the court had no right to get involved here, vote no against ratifying the disaffiliation of First Church so that this invasion, this violation from the state is not validated. And so I'm going to do a piece later just going, these two things are not related. You know, whether you vote yes or no does not in any way correct the state. But the larger question here is these neutral principles cases. You know, if we're not talking about class action lawsuits that are looking to overturn a precedent of law, but you're just looking for a court to wade into the waters of an individual church case, do those have any impact on jurisprudence whatsoever? Can they change norms in the exercise of state law over denominational bodies, or is this just nothing? It has no, what they're saying, this is really, you know, this is a change in American law. Does it have implications so far as norms in First Amendment protections of religious rights?
Well, I'm not sure I understand your question in full, but
Okay.
let me just offer a few
Yeah.
thoughts. Federal law is relevant. I mean, church property cases are based on state law, but the federal Constitution and the law that's been developed around it sort of sets some outer boundaries that state courts cannot go beyond.
Right.
And in my perception, there's in this current application of 2553, there is, I think, a general correlation between the conferences that have been most draconian in interpreting and applying 2553, maybe applying it in an uneven way, as occurring in Oklahoma apparently, or imposing high financial requirements, like in California, or trying to suspend things altogether, as occurred in Georgia and Arkansas. There's a correlation between the conferences that tend to do those sorts of things and the states where the deference method is used, like Florida, New Jersey, California, arguably, at least to some extent, Oklahoma.
So would I understand you being saying
in those states
they don't pull that crap in Texas because they know in Texas it wouldn't fly? Something
in Texas is strictly neutral principles of
right,
law,
and so they just no, they wouldn't get away with it, so they don't even try it on the conference level.
So conference officials in Florida, California, Georgia know that the local churches really aren't going to have any remedy or recourse in civil court.
Okay, yeah.
So long as they avoid committing fraud, those conferences can act as an extreme a way as they want to.
Right.
And if the local church goes to state court, the state court says, well, ecclesiastical abstention doctrine, or if we do have jurisdiction, we apply the deference method.
Yeah.
And the conference wins. And so the conference in those states know that they're kind of in the catbird seat.
Mm-hmm. Yeah.
And the local churches really don't have a lot of bargaining strength or negotiating leverage. Mm-hmm. And the conference can kind of run roughshod to a degree that they often can't in states where a local church may have a valid claim to make that the trust is unenforceable.
Right.
In Texas or Kansas or Ohio or wherever.
Mm-hmm. So some of these cases, like, was Louisiana a deference state or a neutral principles
Louisiana
case?
is a neutral principles of law state.
Okay, so then that one, it wasn't very difficult necessarily to push back against the conference as it was. And you said that Mississippi was a deference state.
Well, no, Mississippi is a neutral principles of law state.
Oh, okay. So that would explain why they were okay.
And in the Shreveport matter,
yeah.
While neutral principles of law applied, the Shreveport church had an extremely complicated deed record.
Okay.
With something like 90 different parcels put together over a 150-year period to form a contiguous 5 or 6 city block tract. Mm-hmm. Some of those deeds had trust language in it. In fact, many. Some didn't. And so the Shreveport church would look at a very challenging situation if it landed in court, even though neutral principles of law would apply. But fortunately, they were in an annual conference that was not imposing some extreme percentage of net asset value as a condition for giving them a quitclaim deed.
Okay.
They only had to pay a couple of years of apportionment, and I think even the pension thing was waived, if I recall correctly. So the financial terms and conditions of dismissal were enviable. The real issue was after so many churches had already left the preceding year, whether there'd be enough traditionalist churches at the annual conference to ratify the congregation's vote.
Right.
And in fact, it ended up being ratified by an overwhelming margin. And the matter was satisfactorily resolved without need of going into court.
Well, am I right in remembering that litigation began whenever the conference was dragging its feet and letting them even take the church vote and go through the 2553 process?
This is a very interesting situation. What happened was some of the, I'll call it more progressive, more far left advocates of progressive theology and LGBTQ interests were unhappy with the conference for what they perceived as being too lenient in letting churches go without holding their feet to the fire with extremely high financial demands. And so some retired Methodist ministers banded together and filed a lawsuit seeking to enjoin or block the whole conference from any further proceedings under 2553. Now, First Church Shreveport was in the middle of that process and was headed towards the exit door under favorable financial or fair financial terms. And they wanted the proceedings to continue. And so we actually intervened. So the conference was a defendant in a lawsuit filed by the progressives to block 2553 entirely. On behalf of our client, First Church Shreveport, we intervened in that lawsuit to align ourselves with the conference to argue that these plaintiffs were violating the ecclesiastical abstention doctrine.
That is
interesting. The ordinary application of 2553 is an internal ecclesiastical matter of administration that civil courts can't weigh in on.
Right.
And we were successful in persuading the trial judge that that's correct, and he dismissed the lawsuit. The conference was then free to proceed with the next steps in 2553, hold its ratifying annual conference, and First Church was approved and let out, along with about 90 other churches.
Yeah, from afar, it wasn't ever very clear to me who the main people gumming up the works were, if it was the conference or if it was, I knew that there was some group of retired clergy that leaned left, but I should have known to call you and get the details. Now, the situation in Dothan at Harvest Church is a very different situation. They are, Alabama, West Florida, I did cover them and report on them for a bit. They were pretty fair in allowing churches to disaffiliate until after this last wave. But Dothan, Harvest Church had filed even before, and they're taking a very, I would consider a biblically faithful position, just saying, no, we're not going to pay a ransom fee. I think that's what I've heard some representatives from there saying.
Yeah, the Harvest Church is in a enviable, in my view, position, a position which probably most Methodist churches aren't.
Okay.
Many Methodist churches, like the church in Dothan, are located in a state that applies neutral principles of law. But you have to have good facts to take advantage of that law. And many Methodist churches don't have good facts. Their deeds and articles do contain trust language. The church in Dothan, however, is clean as a whistle. There is no trust language, direct or indirect, in its articles or its deeds.
Okay.
So it's sort of been a perfect world where the facts and the law really align. So if they went into court, they have a very strong case. And they felt that the fees that the conference was requiring, and in particular, I think it had to do with my law partner's been handling this. I farmed it out to him. Had to do with the calculation of the pension amount. There's some funny numbers going on, or so it seemed. And so the local church instructed us to file suit on its behalf to have the state court declare that the denomination's Sword of Damocles was an emperor with no clothes.
Okay.
That there, in fact, was no trust. And so in response, the conference filed a motion to dismiss our suit, alleging that this was just a matter of internal ecclesiastical administration for which you have no jurisdiction to decide one way or another. We said, no, it isn't. We're not talking about how 2553 is or isn't being applied.
Yeah.
Our lawsuit simply asks you to declare the property rights.
Yeah. Clean and simple,
the court agreed with us.
Okay.
And denied the motion to dismiss.
Yeah.
The conference is taking it up on appeal. The lower litigation has been stayed, except for discovery, where both sides are exchanging documents and taking depositions and so forth. So that's where that case currently stands. I'm very optimistic. Granted, I'm biased. My firm is counsel of record in that matter.
Yeah,
put that on the table. But I think the Dothan Church is in an unusually strong position there.
Well, I'm going to bring it back to my main concern, which was rulings on these cases. I guess people like me who are hopeful have been hoping that if judges sided with local churches, that would have implications so far as mandating conferences to either stop using 2553 altogether and let churches go, or make the provisions of 25.3 as bare bones as possible. But what I think I'm learning from you today is these are just case-by-case issues. They don't necessarily have any implications for other churches in those conferences whatsoever, or changing the provisions by which they can disaffiliate. These really are just isolated.
When I was advising a church in another denomination many years ago, I analogized the situation to one of these nature shows you see on television, where there's this mass migration. And even though you've got a mass of folks exiting at the same time, each new GNU has to cross the river by themselves.
That is an animal, yes. Okay.
Yeah, and so in most states that apply ordinary property law and corporation law and trust law, as I said, the outcomes are fact specific. And so the things that are now and of course the law in one state is only going to be controlling in that state. In another state, it may have persuasive value, but it's not going to control. Okay. So if you have a court decision, even a Supreme Court decision in a state, it's not going to automatically control coast to coast. And so you're not going to have a single court decision that is going to have repercussions necessarily throughout the entire denomination. Now, the SMU case is interesting. That was just an appellate court was just decided a couple of days ago. The court said that language in the SMU articles that said that the denominational constitution would control, as it might be amended from time to time, including the addition of trust language, did not create a trust over the SMU property. And sometimes when there is no express trust language, denominational lawyers have argued, and some courts have held, that a trust nevertheless was created indirectly by that language sort of being bootstrapped.
Yeah.
But the Texas Appellate Court said, no, under Texas law, that doesn't create a trust.
Interesting.
Now, it did create a use restriction, and the conference did prevail in most parts on appeal.
Okay.
But that portion of the decision that interpreted that language is I think significant and will have some reverberations in other states.
The last time I read about the SMU case, SMU, Southern Methodist University in Dallas, Texas, one of the 13 seminaries of the United Methodist Church. My family members have gone there. The trustees of the seminary decided to try and legally separate themselves from the denomination at that time because the denomination's stance was not affirming of LGBTQ persons, and that was the reason that they used. As the ground shifts in the denomination, I'm not sure that they've continued making those claims, but it sounds like it's climbed the rungs of this ladder to higher court systems where decisions are being made right now as to whether or not they can boot United Methodist leadership from their trustees, boards, and agencies at the SMU. Is that what's at stake there?
Well, it's really control over the assets of SMU.
Okay.
As managed by the board of directors of the SMU Corporation.
Okay.
And who has control of that. And the SMU articles of incorporation, of course, SMU dates back to 1911 or 1916 or something.
Yeah.
But the last time the articles were amended until an attempt just recently in 2019 was 1996.
Mm-hmm.
Going into the litigation, those were the operative articles. And those articles of incorporation say something very unusual that I've not seen elsewhere in local churches. The articles say that the board can amend the articles of incorporation. Well, first of all, the articles state that the property will be subject to the control of the conference. That's in the articles.
Okay, that seems pretty
The articles
clear.
go on to state that those articles can never be amended.
Okay.
Unless the conference gives its permission.
Okay, sure. Yeah.
Now, what the dissenting board of SMU did in I think it was 2019, if I have the dates correct, they went ahead and amended those articles unilaterally.
That they were actually not allowed to do by their constitution.
But by the prevailing articles at the time.
Yeah, okay.
They did not seek conference approval. And so they amended the articles to sever themselves from the UMC and remove UMC references in their articles and did not seek conference approval for that.
Okay.
And they felt that they had authority to do that under Texas law.
Right, yeah. Because Texas is not
a conference said, no, you don't, under Texas law. The 1996 articles control, and if you're going to sever yourself from the UMC and remove those references in your 96 articles, you have to get our conference permission. And so the court was called upon to decide who was right under Texas law.
Yeah.
And the appellate court essentially, in most respects, ruled in favor of the conference.
Interesting.
Now, there's a matter of how to interpret a certain Texas statutory provision.
Yeah.
And that may be grounds for appeal as the case goes forward. But there was an 83-page opinion on this matter just issued, I think, just a few days ago.
So what I've wanted to do with this rhetoric from the annual conference about our vote on Saturday in Oklahoma is, as they're extrapolating all of these large First Amendment implications for this court involvement here, I've wanted to say, that's hyperbolic. That's way beyond the pale. There's no way that this is going to spin out into anything that has larger implications for First Amendment law in America. I've kind of pushed in that direction to see if you'd agree with me on that. And I think what I understand you to be saying is, no, interpretation of U.S. law, even constitutional federal law, sometimes there's a big deciding case at the top that really changes jurisprudence. But sometimes it's a series of thousands of news crossing the river that really creates a different norm where you revise what has up till now been an understanding of how the state interacts with ecclesiastical authority. So,
Yeah. However, the Oklahoma court decides that matter, lawyers and conferences and courts in other states are going to look to the body of U.S. Supreme Court case law on the boundaries and how to interpret the ecclesiastical abstention doctrine. Um, it may have ramifications elsewhere in Oklahoma and in that particular conference. And so it's maybe worth fighting about legally for those reasons. But even in another case in Oklahoma, whether or not the deference method is going to apply strictly, or whether or not the judge has some latitude because of some inequities, the facts that are present in the first church case may not be the facts present in that other case.
right.
So even there, what the legal outcome in that case isn't going to automatically control in every other church in Oklahoma. So, I would think the best approach at this Saturday annual conference is an appeal to just fundamental fairness. Apart from the legal arguments, pro and con, what's right under the facts of this case,
right,
as presented, and an appeal to conscience. Now, whether that's talking to a brick wall at that juncture or not, I don't know. But I think an appeal based on fairness, and of course, both sides have been negotiating financially, and in almost every instance, common ground financially can be found, and then folks can do the paperwork. And it seems unusual that the financial positions of the conference would be so extreme, the demands, and what the local church is willing to pay would be so paltry that there couldn't be some movement to come to some agreement, and then it gets rubber stamped. Now, going into that ratifying conference, I believe the way it works under 2553 is that church and that conference would have signed a disaffiliation agreement that sets out the financial terms and conditions.
Yeah.
And so the parties have come to a meeting of the minds financially, but there's now a move afoot not to give the final required blessing under 2553 with conference ratification.
Yeah.
Because some alleged shenanigans occurred in imposing some additional requirements, and now the judge has stepped in and said, no, you got to do it this way.
Well, we'll see what happens Saturday, and I'm hoping that I just sit down and shut up. I have a pattern of getting up and talking, and I'm hoping that my talking on the front end on the internet can just help me sit down and shut up on Saturday, and that there is indeed a concern for basic fairness and rightness and justice and equity.
This does illustrate a problem with 2553.
Oh, there's only one?
Well, 2553 is a positive thing as opposed to a denomination not having any administrative exit path.
Sure.
The problem, and there are some common denominators in 2553 that all conferences have to follow. But within 2553, a lot of discretion has been delegated to annual conferences and their bishops and their district superintendents as to how to implement it.
Yes.
And that leaves you at the mercy sometimes of the personality or ideological convictions of a particular bishop or a particular district
Yeah, the
superintendent or a
superintendent,
majority
yes.
of a board of trustees.
Yeah.
And so 2553 is not a perfect vehicle by any means.
No.
And this litigation erupts when I think one party or the other tries to exploit the opportunities that those gaps have given it.
Right. I can, so I will. It's a real problematic mindset. I understand it in a worldly setting, but for it to be utilized in a church setting sure is scandalous, in my opinion.
It's in my experience, and I've done this for almost 20 years with executive presbyters, bishops, district superintendents, local pastors, and the lawyers that represent them. There is sadly all too often a lack of grace and ironic spirit. Oftentimes, to their credit, there is, but it's not a given.
Right. You can't
by
take it
any
for granted.
means.
Yeah.
And the mistake that a lot of local pastors make is assuming that grace will be extended, that an ironic spirit will prevail, and they put too much trust in the relationships they think they've cultivated when property hasn't been an issue. And sadly, the tactics can turn pretty hardball pretty quickly.
Yeah. Yeah, it's not in the Bible, but the truism, hope for the best, prepare for the worst, has always seemed like a good approach in a number of fields. And so as we're closing up this conversation and we're thinking of the congregations right now that are still in the United Methodist Church that are pretty sure they're not going to be happy within the denomination in the future, and they're wanting to have this conversation late rather than never, is there any guidance that you can offer these churches that are every conference is different, so we can't get into the nitty-gritty of each conference. But if you were the legal counsel for just average, medium to small church, not made of money, that's wanting to think about disaffiliation, is there any kind of encouragement to offer? Is there any kind of wisdom to bestow at this point? Or is it kind of just, hey, this is the Wild West, do what you do? Yeah.
Most conferences are not imposing draconian financial requirements. And there is a lot of lawyering that has to be done as you go through the 2553 process, but usually it's a process that doesn't take more than $5,000 to $7,000 worth of legal services. Sometimes you got to incorporate, you got to look at review deeds, you got to transfer assets and so forth, because the conference requires that. But it's administratively, at a minimum, a 2 to 4 month process. Because the 2553 process is multifaceted.
Yeah.
There's step A, B, C, D, and E, and so forth. And so under the best of circumstances, it's a 2 to 4 month process, the last step of which requires an annual conference ratification vote.
Right.
And most annual conferences have meet in ordinary session annually in May or June.
Yeah.
Been my experience.
Yeah.
And if they have a additional convocation or gathering or session in an extra annual conference, which many have done just for this 2553 purpose, most conferences have already had that this year.
Right.
I mean, a few may be later in the year, but not many.
So for thousands of churches, the timeline is already closed for them.
Right.
Yes.
And so this window of opportunity that 2553 presented is rapidly closing without any assurance that anything is going to replace it. So a local church would be only left with litigation as an option. And they would need to hope that they're in a neutral principles of law state, as opposed to a deference state, and they would need to hope that they have good facts,
Mm-hmm.
that there's not trust language in their deeds or articles.
Mm-hmm.
So to determine that, they need to, I would think, retain counsel with relevant competency to review their articles and deeds to determine the strength or weakness of their legal position. Because they're not going to have an ecclesiastical administrative option
Mm-hmm.
for all practical purposes much longer, if they even have it now, with the time requirements of 2553. And they may or may not have legal recourse as an alternative.
The other option that I've talked about on a segment recently is there's a paragraph 2549, which is declaring exigent circumstances and closing a church building. And then some conferences are creating a provision where they sell the church back to the community. And so it's probably not going to be an option for richer or well-located churches in urban or suburban areas. But for smaller rural churches that have a building that would be an albatross because it would...
Right. Yeah, there is an administrative way in other provisions in the Book of Discipline.
Mm-hmm.
It's going to require a cooperating, beneficent, gracious conference
Yes.
to work with the local church. It would require a situation where it's not an asset that the conference wants to assume authority over.
Right.
You know, they don't want to pay the insurance and the light bill and the lawn maintenance, and they can't repopulate it because it's in some sparse rural area and so forth.
Mm-hmm.
And so it's got to be in the financial interest of the conference to convey it to the local church.
Yes.
Or give a quitclaim deed, since they're not the legal owner to begin with, convey
Right.
a quitclaim deed for a relatively modest sum.
Mm-hmm.
So there may be some alternative options going forward.
Yeah.
But the circumstances have to be right.
Yeah. So for richer or well-located churches in conferences where the door has already closed or they just don't make it out before 2553 expires, there's not a lot of hope as it stands for a practical exit outside of litigation in a friendly, neutral principle state if your legal documents have the right language on it. So we're looking realistically at probably hundreds, maybe a couple thousand churches really being stuck somewhere they don't want to be. And in that event, you're looking at gritting your teeth and bearing the theology and ecclesiastical exercise that they find really bad, or litigation and losing, or just leaving the building and assets behind and starting afresh somewhere. But those really do seem to be the only options, right?
Well, it's possible that they could litigate and prevail. The question is, if there is trust language in their articles and deeds,
right,
can that language be rescinded or revoked by amending the articles and correcting the deeds under the state law where that property is located? Some trusts are irrevocable.
Right.
Some trusts are not. They can be revoked. And that's a state law question. So I would think a church would be penny wise and pound foolish not to pay some competent lawyer a modest sum to examine their deeds, to examine their articles, see if there's problematic language or not.
Mm-hmm.
And if there is, whether the law of the state allows that to be rescinded and corrected so that that local church is better postured legally going forward to exercise whatever options it might feel it needs to, depending upon what might happen in the future.
Well, that's a lot of good information. I already knew, talking to you before, that you'd be a wellspring of information, and you've been very gracious with your time and your energy and your expertise in this time. Lloyd, for anyone who watches this and they just really want to learn more and sink their teeth in more, just briefly, what do you think that they should do? Is there a website they should go to, a book they should get? Would you have them reach out to any law firm in particular?
Well, your average litigator isn't going to be familiar with this very niche area of the law.
Right.
If they go to a real estate lawyer, most 99% of the real estate lawyers are folks that do closings when you buy or sell a property. This is a different kettle of fish here. There really are very few lawyers around the country that handle this type of thing and have any familiarity with it. I'm semi-retired. I'm trying, as we talked about off camera, I feel a little like Michael Corleone in Godfather 3. Every time I think I'm out, I get pulled back in. And so I have trained some very capable younger lawyers at my firm that do a lot of this nationwide. If they are interested in exploring retaining someone from my firm or someone in their other part of the world through a standard engagement letter, I can kind of walk that process through with them. If they wanted to contact me at the Taylor Porter website, which you can post or give.
Okay.
But the nuts and bolts, I'm really passing to others.
Okay.
I've been donating a lot of time. I'm not trying to gin up business by saying this. But I think it's a smart thing for any church to know what its own deeds say.
Yeah.
And what its own articles of incorporation say.
Yeah.
And whether that gives the denomination a right or not, and if it does, can that be changed?
Yeah.
That's a preliminary threshold inquiry that I think any church ought to make, regardless of what decisions they're going to make going forward, that they'll be more informed.
Yeah, knowledge is power. Okay. Well, I think that's a great note to end on. So Lloyd has told you, friends, how it is that you can follow up with him or on this subject and potentially serve your church and potentially learn some very helpful things. I hope that this has been a very helpful time for you to reflect on what your church is going through, has gone through, might go through, and make better decisions going forward. So Lloyd, once again, finally, thank you so much for joining me, and God bless you as you enjoy semi-retirement.
Well, thank you. I have tried to put these legal concepts in conversational English as best I could.
Yeah.
If someone, these ideas of trusts and neutral principles and deference and so forth are foreign concepts to most people.
Right.
You have my contact information, my email address. If you want to post it, you're welcome to do that.
Okay.
And I can respond briefly to most folks and then refer them to someone who can handle the matter for them if they want to take a deeper dive.
Neat. Thank you, Lloyd, and thanks to everybody for supporting PlainSpoken. I enjoy doing this stuff, so make sure if you ever have stuff you think I should know, you can email me at plainspokenpod@gmail.com. And I'm on Facebook and YouTube and Twitter. I'm all over the place, so make sure to like and subscribe and follow me wherever you are, and we'll see if we can't continue to be an encouragement to those who are feeling really discouraged in the United Methodist Church. And we're going to just encourage the larger Wesleyan body of people outside of the United Methodist Church and the GMC or what have you. So it's a fun project I'm a part of. I'm glad to have so many of you on board with me and join up. All right,
Thank
we'll
you,
see you
Jeffrey.
friends later. Yes.
And God bless you.